Is an arrest for criminal sale of a controlled substance proper, even when the officers don't see drugs actually change hands? To find out, you have to read People versus Tapia, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Tapia. The citation for this case is 2025 New York Slip Opinion 04940, published by the New York Court of Appeals on September 11th of 2025. The issue in this case is whether an arrest of an individual for criminal sale of a controlled substance can take place absent the arresting officer seeing a hand-to-hand interaction where they actually see drugs being handed to an individual, like a glassine envelope being handed off. To understand and appreciate the context of this case, the helpful background to know is that there's something called the DeBoer levels. This comes from the case called People versus DeBoer. And in New York, this DeBoer case sets out the requirements of what information the police must have before taking a given action with an individual who's a civilian. There are 4 levels of interaction described by the DeBoer case. Level 1 is the right to approach and request information from an individual. And before they can do that, the police have to have an objective, credible reason to interfere with an individual. Number 2 is the common law right to inquire, which is sort of ask more intrusive questioning. And to do that, the police must have before that a founded suspicion that criminal activity is afoot. The 3rd level is the right to stop and detain. And before the police can do that, they have to have reasonable suspicion to believe that a crime is taking place or the defendant committed a crime. And the 4th level is arrest, the right to stop and arrest an individual. And before the police can do that, they have to have reasonable cause to believe, otherwise known as probable cause to believe, that a crime has been committed and the defendant committed it. So before the police can arrest and seize somebody, they have to have probable cause to believe that a crime has been committed and the defendant committed it. So in that context, the facts in this case, the alleged facts in this case are that the defendant here was indicted, was charged, was arrested and indicted for various drug-related offenses, including criminal sale of a controlled substance in the 3rd degree and criminal possession of a controlled substance in the 3rd degree. He was arrested, and on his possession, they ultimately found drugs on his possession. He moved to suppress the physical evidence recovered, the drugs, as a result of his arrest or during his arrest, based upon a failure of the police to have sufficient reason to stop him and arrest him. The Supreme Court held a suppression hearing, and at the suppression hearing, Officer Perez, in this case, the arresting officer, described the arrest. In the testimony of the suppression hearing, the officer mentioned how he was with another officer and a sergeant in a car watching in front of a motel where there'd been numerous drug-related arrests. His attention was first drawn to the defendant because he saw the defendant wandering around outside of the hotel and nervously looking around, which prompted the sergeant to tell the officers to keep an eye out on him. Officer Perez indicated that he saw the defendant speaking for a few seconds with a woman who the officer knew had been arrested multiple times for narcotics possession. The 2 touched hands, the defendant and this woman. They separated. The woman walked for a block or so, turned around, and returned. The defendant, while she was away, reached between his pants and his body. The defendant pushed something into her hands. He did not see what the defendant put into her hands. That's important here. He saw that he put something in her hand. She clenched her fist and walked away. Ultimately, the defendant was arrested, and so was the woman. And ultimately here, on the suppression decision, the judge ultimately found that there was sufficient grounds for the arrest and the search and seizure. The appellate division affirmed. It goes to the Court of Appeals. And the question here is, in the absence of a telltale, it's called a telltale sign of narcotics, which would be if the police officer actually saw a glassine envelope containing cocaine pass from one individual to another individual, that would be a telltale sign of criminal sale of a controlled substance. Here, the police officer didn't see that. Instead, there was other things the officer saw, which included factors including the exchange of currency, whether a particular community has a high incidence of drug trafficking, the police officer's experience in training in drug investigations, and furtive behavior on the part of the participants. The other factors were here, but the officer did not see a specific transfer of drugs to an individual. And the holding from the Court of Appeals here is that is not necessary. We don't need to see the actual transfer of drugs for there to be a sufficient cause to arrest in this case. And here there was record evidence of several of those factors, they say, including the nervous glancing, the reaching into the waistband without looking down, 2 separate interactions with the same woman, and involving exchange of an object, even if the officer couldn't see what kind of object it was. That is sufficient, according to the Court of Appeals, for probable cause to believe a crime is committed and the defendant committed it. The search and seizure and arrest is proper. The evidence is not suppressed. And that's the case of People versus Tapia. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.